Introduction. The room that looks like a court. Walk into the room and everything tells you that you're in a court of law. The officer at the front is elevated above you on a raised bench, the black robe, the gavel, the American flag positioned precisely in the corner, the bailiff standing near the door, the formal language. The matter before this tribunal, the respondent will be heard. This hearing is now in session. The physical architecture of the room itself, designed with deliberate symmetry to communicate institutional authority, impartiality, and constitutional weight. Every visual signal in that room has been engineered, whether consciously or through decades of institutional imitation, to produce one specific belief in the mind of every person sitting in it: that this is a court of law, that the officer wearing the robe is a judge, and that the constitutional protections most Americans learned about in civics class are fully operative in this room. That belief, for most Americans in most legal proceedings today, is false. The documented reality of the American legal system is this: fewer than 2% of all legal adjudications conducted in the United States each year are presided over by Article III constitutional judges, the only judges the Constitution of the United States actually creates, protects with lifetime tenure, and insulates from political and financial pressure through salary guarantees that cannot be reduced by Congress. The remaining 98+% of legal proceedings in America are conducted by administrative law judges, hearing officers, magistrates, commissioners, referees, and a host of other officers who are employees of the very government agencies whose decisions they are supposed to review independently. That is not a conspiracy theory. It is a documented structural reality built through more than 8 decades of federal legislation, Supreme Court decisions, and administrative expansion that has proceeded almost entirely below the awareness of the American public. The number is almost too large to process. Every year, more than 1 million people go through Social Security Administration hearings before administrative law judges who are employed by the SSA itself. More than 1 million immigration cases pass through immigration courts staffed by trial attorneys employed by the Department of Justice, the same department whose enforcement arm is seeking deportation in those very proceedings. Tens of millions of traffic and municipal court proceedings are conducted each year before hearing officers who are employees of municipalities that depend on the fine revenue those officers collect. Federal agencies, including the Securities and Exchange Commission, the Federal Trade Commission, the National Labor Relations Board, and the Environmental Protection Agency, operate their own internal adjudicative systems where the agency investigates, charges, prosecutes, and employs the officer who decides the case, and then reviews its own ALJ's decision through its own internal appellate commission. The constitutional framework was never supposed to work this way. Article III of the United States Constitution established a federal judiciary of independent judges with specific structural protections: lifetime tenure during good behavior, salary protection against congressional reduction, precisely because the founders understood that a judge who answers to the government cannot independently protect the citizen from the government. That principle was not incidental to the constitutional design. It was central to it. Alexander Hamilton wrote in Federalist No. 78 that there is no liberty if the power of judging be not separated from the legislative and executive powers. The structural independence of judges was not a procedural nicety. It was the constitutional guarantee that when a citizen stood before a court, the officer sitting in judgment was not the agent of the party seeking judgment against that citizen. The administrative tribunal system has functionally dismantled that guarantee without ever formally repealing it. The Constitution still says what it has always said. Article III, courts still exist. Federal district courts, circuit courts of appeals, and the Supreme Court still operate with constitutionally protected independent judges. But for the overwhelming majority of Americans who will ever encounter any legal proceeding, a disability claim denial, a traffic citation, a child custody dispute, a deportation order, a federal agency enforcement action, a professional license revocation, the Article III court is not the forum they will ever enter. The administrative tribunal is. What this book documents is how that substitution happened, how it operates today, what it costs every citizen who walks into a hearing room believing the constitutional protections apply, and what documented legal tools exist to identify it, challenge it, and in specific circumstances, escape it entirely. This is not an anti-government book. It is not an argument that every administrative proceeding produces unjust outcomes or that every administrative law judge is corrupt. Many ALJs are conscientious officers doing difficult work under impossible caseloads. The problem this book documents is not primarily a problem of individual character. It is a structural problem, a documented constitutional architecture that places the adjudicative officer inside the prosecuting institution, removes the procedural protections that prevent bias from controlling outcomes, and then dresses the entire arrangement in the theatrical costume of a constitutional court to prevent the citizen from recognizing what they are actually inside. The Supreme Court has spent the last decade only beginning, to grapple with the constitutional implications of what the administrative state has built. In Lucia versus SEC, 2018, the court held that SEC administrative law judges are officers of the United States subject to the Appointments Clause of Article 2, invalidating years of SEC enforcement proceedings conducted by improperly appointed ALJs. In Axon Enterprise versus FTC, 2023, the court held that constitutional challenges to the structure of agency adjudication could be raised directly in federal court without waiting years for the administrative process to conclude. In SEC versus Jarkissi, 2024, the court held that the Seventh Amendment right to a jury trial applies when a federal agency seeks civil penalties for common law fraud, a ruling that struck directly at the in-house adjudication model the SEC had operated for decades. And in Loper Bright Enterprises versus Raimondo, 2024, the court overruled Chevron USA versus Natural Resources Defense Council, eliminating the presumption that courts must defer to agency interpretations of ambiguous statutes and restoring independent judicial review of agency legal conclusions. These decisions represent the most significant judicial pushback against the administrative adjudication system in nearly a century. They also represent something else, documented proof that the constitutional objections to administrative tribunals are real, are recognized by the highest court in the country, and are winning. That is what this book is built to hand every reader who encounters any administrative proceeding anywhere in America. The documented knowledge that the constitutional framework was supposed to protect them, the specific mechanisms by which that protection was removed without their knowledge or consent, and the precise legal tools, statutes, case law, procedural demands, constitutional challenges that exist right now to push back. Chapter 1 begins where every citizen's encounter with the administrative state begins, in the room that looks exactly like a court of law and is not one. From there, this book moves through every major tribunal system in America: Social Security, Family Court, Traffic Court, Immigration Court, federal agency enforcement, state administrative systems, documenting the structural fraud in each one with forensic precision, and closing every chapter with actionable constitutional tools the reader can deploy immediately. The American founding document promised access to courts of law governed by independent judges operating under rules designed to protect liberty against power. Most Americans have never received what was promised. Most do not know it. This book is the documented record of what was taken, how it was taken, and what it will take to get it back.